Good afternoon, everyone. Welcome to QITalktime. Today's QITalktime is on the Assisted Decision Making Capacity Act 2015. What is it and what does it mean for our practice? Thanks so much to everybody for logging in. There's huge interest in today's webinar. So just want to welcome our speakers here today. So today we've QITalktime, who is the National Programme Lead for Assisted Decision Making in the HSE. She has extensive experience in this area, both here and abroad. So we're really looking forward to listening to you today, Caoimhe. Also, as part of her team, we have Jacqueline Grogan, who's going to just wave in and say hello. And we also have Mary Tighe, who both work with QITalktime on the national programme. So we will have time at the end for some questions and comments. So please do, we want to make this as interactive as possible. This is about you and you getting your needs from the webinar. So please, we will have time at the end to answer any queries or comments or questions, and also during the webinar. So if anything pops into your minds, please type it into the chat box and we'll try to address them as they come up. So you can listen over the computer. The sound is often better over the phone, so you'll see there the phone number typed in and the event number. So you just put in that code when it asks you for the event number when you dial the number. The chat box is situated at the top right-hand corner of the screen. So if you click on that, and you'll be able to type in any questions or comments or queries into that box. So without further ado, one other thing actually to mention is we are very active on QITalktime at Twitter. So if you're in a room and you're watching this together as a group of people, please do take a photo and put it up on Twitter, or even share any of the slides or comments that you want to share with the wider Twitter community so that we can get the message out there. So without further ado, I'm going to hand over to Caoimhe.
Okay, thank you, Roisin, and hello to everybody. This is very strange not to be in a room full of people, but I know there's lots of people out there, some of whom I know. So what I'm going to do is we're going to start with an explainer video. This is its maiden voyage, which is it's a video about the Act that we filmed over the last year with people who will be affected by the Act, their family and supporters and staff, and it's an explainer video, so it introduces kind of very simple concepts about the Act, and then afterwards I'm going to go through some of the kind of the main aspects of the Act, and then some of the implications for practice. Feel free throughout the presentation to send in questions. We will take questions at the end, and Marie and Jacqueline will also participate in that. And I suppose just by way of maybe explanation as well, this is a very short introduction to a very complex Act. So if throughout the presentation there are certain aspects that you'd like something more specific at a later stage for another QITalktime or for another session on it, we're more than happy to facilitate that. I suppose the other thing to say is, in relation to the explainer video, there's a couple of typos. It says the mental health services, it should be health services. This is its maiden voyage today, so those will be corrected. The video will be available to all of yourselves to have for sessions with your staff locally. That'll be finished probably in the next couple of weeks, and we'll make that available. We'll send it out. We have your email addresses, so we'll make sure you get access to that. And then there will be a formal launch of that then later on in the year. So we'll start with the video, which is self-explanatory, and then I'll kind of reiterate some of the key points that are in the video then afterwards.
We all make decisions, big and small, every day of our lives. Most of us are able to make these decisions by ourselves. There are many people accessing our health services whose ability to make certain decisions about their life and choices may be affected by a disability, an accident, a medical procedure, or a chronic illness, either on a temporary or permanent basis. A new law called the Assisted Decision Making Capacity Act 2015 has been passed, which gives people the right to be assisted to make decisions with legally recognised support, regardless of disability or any condition which may affect their decision-making capacity. The Act is for everyone over the age of 18 who has difficulty now or who might in the future have difficulty making decisions. A number of decisions are covered by the Act, including day-to-day decisions, what to eat and what to wear, through to more complex decisions like whether to buy or sell a house, or to have a surgical procedure, or what to do with a large sum of money. All services are covered by the Act: banking and financial services, legal services, and health and social care. A number of key features of the Act include: a person has capacity until proved otherwise. A person should be supported to make decisions as far as possible. Information should be provided in a way to a person that is easily accessible. A person has the right to make an unwise decision if they choose to. A person can make an advanced decision about their healthcare treatment, which will apply when she or he is no longer making a decision. The wards of court system will be abolished and a new system will be put in place. A new body called the Decision Support Service has been set up to oversee the Act and is based in the Mental Health Commission. The Decision Support Service has a number of functions, including public awareness of the Act and supervision of the decision-making support arrangements.
The Act taught me the choice of my life. It means I can get to make decisions when I want it, but I still making my own choice. This Act is great because this is my life, and I have the same rights as everyone.
This Act matters to me as Damien's mum because it makes it clear that Damien has the right to make his own decisions, which is really important. It also means that we can get information and advice that he might need to support him in his decision making, now and in the future. The Act also provides reassurance for me that when I'm not with Damien, that he'll be able to get appropriate support to make decisions in relation to all aspects of his life, but that his right to make his own decisions will be safeguarded.
I'm currently making my wishes and preferences known to my husband and son. If I suffer a serious illness or there is an emergency which affects my ability to communicate, my family will know what I would want. And with this knowledge, will be able to support me while at the same time making sure that my rights as a human being are respected.
This new Act encourages us to plan and think ahead, which is so important for us all. The Act will allow me to be legally recognised as Veronica's support person.
The Act allows people to plan ahead and put in place legal binding arrangements about the healthcare treatment they do not want when they no longer have the capacity to make this decision.
I don't want my family making all my decisions. I want to make them myself while I still can. This is my life and my decisions.
This Act matters to me because I will be able to support individuals that I work with to make their own choices in life and to be more involved in what happens to them.
This Act matters to me as a dentist. It is important that the patients I treat have a full understanding of their dental care and treatment options, and that they are supported and enabled to make decisions in relation to their own oral health.
The Act that matters to me because I want to use all my rights to make my own decisions, which is what can happen if a patient is made aware of court. Even if I can't make my own decisions, the Act keeps my wishes and values and beliefs at the centre. There can be no decision without me will.
Assumptions should not be made about a person's ability to make and communicate decisions based on an initial diagnosis, especially in the case of a severe acquired brain injury, that the condition of the person can improve over time.
Mark enjoys life, and a big part of that is being able to make decisions and to let us know what he wants. These decisions range from basic day-to-day decisions
what he wants to eat, what he wants to watch on TV, to more complex decisions about care and treatment. And sometimes Pádraig's decisions surprise us.
I represent public health and community nursing services. We as nurses hold a very privileged position of entering into people's homes and of witnessing the reality of how patients live their lives. Therefore, I wholeheartedly embrace the opportunities that the Act will bring for patients to shape their healthcare decisions. The Act provides an opportunity for patients to have a voice and represents an approach which appreciates the values, needs and preferences of each and every patient. This is achieved when patients are facilitated to become informed decision makers and exercise their choice in a shared decision-making process.
The Act provides legislation for advanced healthcare directives. This is where a statement is made by a person with capacity, setting out his or her will and preferences about medical treatment, which may arise in the future at a time when they no longer have the capacity to make decisions. It will guide the treating doctor to care for the patient in a way that the patient would have wanted, and I believe that will be very helpful in general practice. The area that it will have huge relevance will be transferring persons from nursing homes to acute hospitals who do not have the capacity to say no.
Why does that matter to me? If I'm mental experience, I'll ask questions to make decisions myself. And then there's not a call. That's on my behalf to carry out my decision making. If I'm unable to do it myself.
And this act means that Margaret, the person I love and support, will be happier and empowered if her wishes are both protected and listened.
This act means that the people in my care can be assured that they have the right to access information in a way that can maximise their understanding, and they are to be given more time to understand that information, to help them to make decisions. This matters because it shows respect for the elderly, the patients and their doctors.
The Act recognises that people need formal support to help them make decisions. These formal supporters are called interveners. A person can have a number of supporters to assist them with different decisions.
Nothing about me without me.
Nothing about me without me.
Nothing about me without me.
Nothing about Pádraig without Pádraig. Do you agree with that, Pádraig?
Yes.
That's great. Just to acknowledge that there may have been a little bit of sound interference there. The music, people find it hard to hear, but hopefully you got to read the subtitles at the bottom, and as we said, this video will be available to share soon with just a few final amendments. So thanks, hopefully you find that useful. I'm going to hand back over now to Caoimhe, and we'll go back into our slides. Just bear with us for one moment.
So as Roshan has said, this is the first time we've showed it publicly, so yes, we'll sort out the music. That was a problem, it was far too loud, so don't worry, we'll have that amended in the next couple of days. So what I'm going to do now is just reiterate some of the key messages that you already saw, albeit that you couldn't hear, but I'll reiterate some of those, and then I'm going to talk about what the Act means for practice, and also some information on what's currently happening on the agency that oversees the Act, which is called the Decision Support Service. So I'll talk a little bit more about that. Okay, so there's a number of key components to the Act. It talks about the functional approach to decision-making capacity. So when a person's capacity is assessed, you do so using a functional approach, and I'll talk more about that. There's an organisation called the Decision Support Service that has been set up to oversee the Act. The existing enduring powers of attorney system will be revised. It legislates for advanced healthcare directives. There will be a number of legally recognised persons, which I'll talk about later. and that's new. We don't have decision-making assistant, co-decision makers or decision-making representatives at the moment. We do have enduring powers of attorney. So there's a number of new people that can represent my interests when I'm unable to do so. And the existing system of guardianship, which is called the wardship system, will be abolished once the Act is fully commenced. So the Act defines capacity as a person's ability to understand at a time a decision is to be made, the nature and consequences of the decision in the context of all of the available choices. It focuses on, so the functional approach, which is already in the common law, the functional approach focuses on how the decision is made, not the outcome or the consequence of the decision. So while I might make an unwise decision, can I use and weigh up the consequences of that? It focuses on the functional approach itself is issue-specific, context-specific, and decision-specific. The functional approach states that a person is unable to make a decision if a number of components are not satisfied. So that the person is unable to understand the information relevant to the decision, that the person is unable to retain that information for long enough to make a choice, that the person is unable to use or weigh up that information as part of that decision-making process, and that the person is unable to communicate that decision, whether by assistive technology, by talking, or by any other means. So that's how the functional assessment is undertaken. And again, we can go into that in more detail at another seminar. The Act talks about the whole concept of will and preference. It doesn't focus on best interest. It talks about will and preference, and what that is defined as a person's will is used to describe their long-term vision of what constitutes a good life and fulfilling life for them. Their preference means his or her greater liking for one alternative or another, which can be demonstrated by words, behaviour, or both. So what is that person's will or preference? The Act talks about as well, so if the person now lacks capacity, what would they have wanted to happen before they lost capacity? What are their values and beliefs? And it really focuses on, so while the person may not be able to make that decision, what would they have wanted if they were able to speak on their own behalf? As I said, this concept of best interest, which we use and is in many of our codes of practice, that doesn't exist in the Act. It's not, that language is gone. And we have the concept of that you can do something in good faith and for the benefit of the person. This differs from other acts and in other jurisdictions where you have best interest. So say, for example, in England and Wales, that concept is still there. The Act provides for legally recognised persons who are known as interveners, who can act on a person's behalf to maximise and support them in their decisions. There's a number of legally recognised persons, and again, they're done kind of in order of the person's ability to make decisions. So I'll go through them now. So when you have capacity, when you have decision-making capacity, you plan in advance, so you can appoint somebody to be your attorney, your enduring power of attorney. You can also appoint somebody to be your designated healthcare representative. That's a person that can make decisions on your behalf, healthcare decisions on your behalf, in accordance with an advanced healthcare directive. And I'll talk a little bit more about that in a moment. So you can also then, where your capacity is in question or shortly into question, you may have a decision-making assistant. That's somebody that can help you make decisions, but you're still making all the decisions. So let's say it's somebody who needs to make a decision about surgery. So you might have your sister to talk through the options with you, but you're still making the decision. So even if you have some kind of condition that's affecting your memory, you are still making the decision. A co-decision maker then is where a decision is made jointly. And again, it could be in relation to property, it could be in relation to your healthcare, where you are able to make the decision, but you need somebody else with you to support you in that decision, so the decision is made jointly. And again, there's much more oversight for that because, obviously, because of safeguarding issues and in order to protect that person's interest. Where a person lacks capacity and is unable to make a decision, and the enduring power of attorney or the advanced healthcare does not include any decisions related to that, then you have what's called a decision-making representative, and that's appointed by the court. And the person only has power to make decisions as as determined by a court order. So that's the substitute decision making. So we have advanced healthcare directives. You can make an advanced healthcare directive now, and it will be honoured. What the Act does, is it puts it on a legislative footing, and there's much more safeguards in terms of the role of a clinician practitioner in relation to an advanced healthcare directive. There's a number of things that must be satisfied for an advanced healthcare directive to be valid and applicable. It only comes into effect when the person lacks capacity. Sorry, I just see a point here. Will you get the slides? Yes, they'll be available immediately after the talk time. And if you don't get them, just contact us, which our details will be available at the end. So your advanced healthcare directive is about refusal of medical treatment in advance. So say you had capacity, so I don't want to be resuscitated, I don't want that particular treatment at a point in my condition. So what an advanced healthcare directive does is allow you to plan in advance for the time that you may not be able to do that for yourself. It must be explicit. There's a whole number of checks and balances that have to be in an advanced healthcare directive for it to be valid. You can request medical treatment in advance, but it's not legally binding. But it is a reflection of what your will and preference is. So we already have enduring powers of attorney, and some of you may be an attorney on behalf of a family member or friend. It's an arrangement where a person, the donor, so I am the donor, where I'm giving somebody the power to act on my behalf when I am unable to do so. The difficulty about our current enduring power of attorney system is that it is wide open to abuse, and there are a number of safeguarding issues that arise in it. What this Act does is it puts in much more checks and balances. There has to be much more oversight of the role, because it's quite a powerful role, and there will have to be annual reports in relation to what my role and function is. So I'm going to now kind of switch. So that's the Act in general. I've kind of sped through 170 pages of an Act. I'm now going to talk about some of the implications, which many of you know because you're practitioners, but just to shine the light on these. And these implications have come up in briefing sessions, which both myself, Jacqueline and Marie do around the country, from staff who said, well, what does this mean for this, or these are kind of issues that we need to consider. And we have been flagging this back to Anya Flynn, who is the Director of the Decision Support Service, in terms of what it's going to mean for ourselves in health and social care. So the whole issue of, so the first thing we ask is, are we ready for will and preference? Are we ready to move away from best interests? And as many of you know, like if anybody is given the question, where do you want to grow old? Most people would say, I want to grow old at home. However, there's a reality about that, and that is fundamentally about will and preference. You know, we have 55,000 people plus who have a dementia diagnosis, which is projected to double over the next 20 years, and we don't have a statutory right to home care. So already we're into a difficulty about will and preference. Our nursing home admission is twice the European average. The average home support package is between 15 and 21 hours a week. However, we know that that's much less in certain parts of the country. There's 168 hours in the week. So if I need care, clearly that's not going to be able to support a person at home. Okay. So I suppose the Act isn't about, the Act is about decision making, but it's going to have direct implications in terms of how we deliver our services. So I suppose there's a question about, will we have to recalibrate our policy in order to honour will and preference? And then I suppose the same thing applies in terms of disability services. Any of you that work in disability services will know we've had a programme of decongregation for quite a number of years. We've had a 30% reduction in people living in congregated settings. That is still increasing, but it's been challenged by the housing market and a limited capital programme, and also the recession. And that has huge implications for people's will and preference to live in their own place. So I suppose the question is, can we honestly honour will and preference? Is it a postcode lottery? And Paddy Connolly, who was the former CEO of Inclusion Ireland, had made a point a couple of years ago about the significant numbers of people who have died or have traded one institution for another with a move to a nursing home, and that there's no national policy on admission to institutes that hasn't been put in place. So there are kind of challenges that we are facing, notwithstanding the principles of the Act. The next issue is the whole issue of risk, safety and liability, which comes up all of the time in relation to the Act. The Act talks about unwise decisions, that I have a right to make an unwise decision. It does not mean I lack capacity. I can make an unwise decision, or I can make a decision even if it results in my death, so I can refuse resuscitation, I can refuse life-sustaining treatment in my Advanced Healthcare Directive. And I suppose the question is the person able to really understand that? And risk then is defined as the likelihood of a hazard causing harm. So I suppose the question then is, what happens when will and preference is no longer safe? My will and preference is to go home. Clearly that might be risky given all that I've outlined in terms of not having the supports for the person at home. So what do we do then? Or where a person wants to continue to make decisions, alcohol obviously being one of them, there's lots of other decisions. What do we do in the face of that? And people are quite concerned about what does that mean. The kinds of questions that people like yourselves have raised is, what level of documentation will I need in the instance of an unwise decision? How many people need to sign off an unwise decision? What will be considered as reasonable to have undertaken in outlining risks? So to what extent do I need to flag all of the possible risks that are going to happen with this person? What protections will be in place where a person supports a person to do something that clearly they know is risky, but they have capacity to make this decision and it results in an adverse outcome? We all know that we work in an environment where social media plays a big role, the media itself plays a big role, and we can't predict what a coroner is going to say. There's fear about, I make this decision to support a person and it's going to end up on Joe Duffy. I suppose this is a reality of where we're moving into in terms of greater autonomy, and with that comes risk. There's a really interesting book by a guy called George Schmuckler called Men in White Coats, and who talks about risk and who talks about the consequences of risk, but says that the sad truth is that we're very poor at predicting the very events that are the most tragic and that we most wish to prevent. So I suppose it might need a new calibration in terms of thinking about risk. Then we have the matter of the Hippocratic Oath in terms of first do no harm. Many people have said, well, what does this mean in terms of our code of ethics? This act is saying, well, do nothing in some instances. So clearly, the codes, all of your codes of ethics, whether it's nursing, medicine, CORU, paramedics, will have to align with the principles of the Act because the Act is primary legislation, and that's work that's going to have to happen over the next coming months and year. So the capacity assessment tool for decision making will be the functional assessment. Many of you will be familiar with the mini mental state exam. This, under the Act, this is not the tool to assess decision-making capacity. It may be used in other contexts, but not in decision-making capacity. And some people feel, that might be a bit of a challenge for a period of time until people are confident with using the functional assessment. Then we have the whole issue of next of kin. Many of you know that next of kin has no legal authority to consent or refuse treatment on behalf of another. And this will have direct implications where a person has been making decisions on another person's behalf who lacks capacity for their entire life. This Act says that, well, the law existing says that they don't have authority, but this law says, well, you should have the legal authority to do that. But what is interesting is that we know that the practice of next of kin is widespread across all services where people make decisions on a person's behalf in every context. And this is a piece of work that was done by SAGE Advocacy, an advocacy organisation for older people, where they asked people which of the following do you feel is the role of your next of kin? And I'll just walk you through. And this is going to be a direct challenge in terms of the decision makers under the Act. So 70% of the people that were surveyed said it was somebody such as a close relative or friend who I would like contacted in an emergency, which is exactly what next of kin should be. Over half of those surveyed said it's somebody who can make healthcare decisions and consent to medical treatment if I'm unable. Over half said it's somebody who can make personal decisions about me if I'm unable. Over half again, someone who can make a decision about life support treatment for me. over 35% then the only person to be given medical or personal information about me, and then again somebody who can access my bank accounts and assets if I am unable. So clearly this is going to be a significant challenge for us in terms of educating people about the rights of a person, that family, close friends do not have those rights, and that next of kin isn't an authority and has no legal basis. So I think we'll collectively will have to do quite a lot of work to support people to transition into the new arrangements. So for the last bit then I'm going to talk about the work that's currently happening in relation to the Act and in relation to the infrastructure that needs to be put in place to support the transition into these new arrangements. So the organisation that has oversight is called the Decision Support Service. It's based in the Mental Health Commission. This is the director, Anya Flynn, who's been in place over a year now. She is a mental health, she's a lawyer with a specialist background in mental health law and human rights law as well. She's now recruiting her team. There's a number of people that are now in place. There are 17 codes of practice in relation to the Act, a number of which, 11 that have been developed by the National Disability Authority, one that's being developed for the financial profession, one for the legal professionals, and then we, the health service, ourselves, the HSE, has developed the 3 codes for advanced healthcare directives and then one overarching code for health and social care. Those codes have been, are now in draft form, and they're now with Anya Flynn for a further national consultation, because some of the NDA codes were not, there wasn't a consultation on those, so that consultation will happen towards the end of this year, and we'll keep you posted on that. We'll make sure that people know about that. There will be the Decision Support Service is going to start doing a public information campaign on their role and their function. Their function is for people that will need the Act. Our role is to support staff in relation to what the Act means for practice. They will also have a number of panels and registered, so there's quite a lot of work that needs to be put in place in order to have full commencement. The Act hasn't fully commenced. Aspects of the Act have commenced. Full commencement is expected by Q4 of 2020, but that's contingent on a number of elements. So obviously the courts need to be ready for a transition into a new arrangement. So in relation to our office, so we have we manage the HSE Assisted Decision Making and Consent Office. So our function is to support staff and frontline services in relation to the Act, what the Act means for practice, to provide guidance and documentation. So once the code is signed off, we'll be providing a guide for staff and following and supporting documentation. We're just in the process of starting our education and training components, so there will be an e-learning programme on the Act. The Act isn't fully signed off yet, so we can't release training elements just yet because we have to wait for the regulations. The regulations are being written at the moment. We need to wait till the codes of practice are fully signed off before any training takes place in case there's some change within that. We have a website, www.assisteddecisionmaking.ie, and we have information on the Act on a regular basis, and we're available to take questions and provide briefing sessions on it. We are also about in 2019, then we have a number of actions planned. We have ongoing briefing sessions around the Act. Some of you that are listening to this have been on that. We're available, and you can get our contact details at the end to provide that. We provide that on site to staff around the country, and we try to do that in collaboration with people within services so that it's much more interactive and practice-based. We're just about, as I said, to start the e-learning content for the ADM, for the Assisted Decision Making Act, and also for the National Consent Policy. We manage the National Consent Policy, and we're just about to undertake a national review of the Consent Policy because there's been a number of legislative changes since 2013. That process will start in June, and we hope to have it completed by the end of 2019, obviously contingent on some other factors as well. We also will be looking at reviewing the Do Not Attempt Resuscitation CPR policy, which is part of the National Consent Policy, but we're going to separate that and have that as a standalone policy. And again, there'll be information about that as we progress with that. We intend to undertake a number of masterclasses in autumn of this year, and we'll be interested from people that are listening today what would be helpful for yourselves. The feedback generally from staff is that we need something on consent, that there needs to be training on consent, but also masterclasses on consent, informed consent. On supported decision making, what is it? How do you do it? Are we doing it already? What does it mean? And also, how do you undertake the functional assessment? So there are 3 key things, but there are others that we're open to planning with you in collaboration with yourself. We are already working with a number of CHOs and hospital groups, and we are in constant contact with the Decision Support Service, and those masterclasses will be done in collaboration with Anya Flynn's office, so that we're able to keep up to date with what's happening in relation to the Act. So, to summarise then, it's a big Act. There's a lot of components, so it's about decision making, it's about advanced planning. There's a number of kind of legal, technical aspects, but fundamentally, the main message is it's about enabling a person, regardless of what condition they have, regardless of what their age is or disability, to be in the centre of the decisions, to have autonomy for as long as possible, and where they start to lack that autonomy, that they have the people, they have supporters that keep them and their wishes and preferences at the centre. That's kind of the simplest story from the Act itself. These are our contact details. We're available by email. If you want us to follow up with you directly, please feel free to get in contact with us. So, thank you. And we're now available to take questions.
Thanks a million, Caoimhe. Excellent talk time. I'm going to invite over the other 2 team members, Jacqueline and Marie. We'll squeeze around here so that we've got all the team together. Now, I'm just going to scroll here on the chat box. Now is your time to please type in any questions or comments there. This is your webinar. We want to hear from you, so that we can meet all of your requirements. So just looking at the questions here in the chat box, the video is very effective. Looking forward to sharing it with colleagues, which is great. There was one about the HSCP office. So the draft guidelines for the Act have had the consultation phase completed. When will these be available for HSCPs, health and social care professionals, to use?
Okay, so we started off in 2017. We started off with draft guidelines. Move around a little bit here. We started off with draft guidelines, and then we were asked by the Decision Support Service to write the code of practice, which we've just done. We've just submitted it to Anya Flynn. There are a number of aspects that we flagged with Anya Flynn and with the Department of Justice about, so things that you had come back with in terms of the consultation, that what's an intervention, what does that mean in the context of health, when does an intervener, is a healthcare professional an intervener, who assesses capacity, when do they assess capacity, when does it go to court? So these are outstanding issues that we're still waiting for a response on. So we hope that the codes will be signed off by the end of the year. Once those codes are signed off, we then will develop guidance, and that then will go into the system, hopefully by early 2020, but it is contingent on, we don't want to put out guides on the Act when the regulations haven't been written. So once they're ready, then we'll put them out there. But we still will be doing briefing sessions so that staff know the fundamentals of the Act in the meantime.
Great, thanks. Another few questions coming in here. We have one from Valerie Toomey, who's actually in the NRH. So will the functional assessment be completed by a number of assessors and signed off by all parties?
The Act doesn't say that has to be done, but best practice says that should be the way it is. What the Act says is it's not prescriptive in terms of how the functional assessment is done in general. We have guidance in terms of the guide that will go out to staff will be that it should be done in a multidisciplinary way. The Act doesn't say that one particular clinician has greater authority than the other. And the Act is quite prescriptive that you do need to have capacity assessed in order to have a co-decision maker. So it says you need to have an assessment by a registered medical practitioner and another healthcare professional. It hasn't defined who that is at the moment. We anticipate that it's going to be those that are registered with the registration bodies. But again, that's not 100% just yet, but that's what the kind of feedback that we're getting will be nurses, allied health professionals that are with registration bodies. Do you want to say anything on that, Marie?
No, just maybe to say that you don't actually, lots of people wonder whether you need a form to do it. You don't actually need a form to undertake. You go through the 4 components of the function and assessment.
Okay, great. We have loads of activity here in the chat box, so we'll just come back up to the questions here. So from Brenda Hutton, where do you advise that unpaid decision-making supports for adults with ID will come from?
Okay. So that's, yeah.
Well, I suppose, again, it's those who are caring for the people on a day-to-day basis and involved in decision-making in all of the decisions that they make, even from, let's say, getting dressed in the morning time to what they want to eat for the dinner. And then I suppose it's about building their capacity to make bigger decisions when it comes to money, etc. But essentially, it's those working with them already.
Yeah. So I suppose just to clarify that where a person will need who lacks capacity and cannot make decisions on their own, will need a designated healthcare representative, they will be paid. It's not a paid position, but they are reimbursed for expenses that they incur in that role. It's highly likely that most of the decision makers are going to be family, because they are mostly the decision makers anyway. But they are still entitled under the Act, if they are the designated health, if they are the decision making representative, that they are also entitled to compensation for or reimbursement for those. But the others are envisaged to be unpaid. Yes, that is correct. Yeah.
Thanks for that. Great, there's so much interaction from everyone online. Anne Dolan has asked, are there any documents already developed and in use in the HSE for decision making establishing capacity in relation to a particular decision?
Again, I suppose the biggest document that we have is the code, and what we will look at is maybe taking some of the sections out of that in the meantime for later on this year, because I know people need some information. Our concern was releasing information that may change if certain aspects of the Act change. We want to be consistent with the message, but we can look at. I mean, certainly there is information about supported decision making that we can share, and we can do that later on this year.
And when we're sharing this online, we will embed the links for your site and everything where there is some information up there. So Anne is saying there's lots of documents available from numerous NHS trusts, but that's exactly what you're saying.
Okay, and what I would suggest is the NHS, the England and Wales and Scotland and Northern Ireland law is different from our law. It's very different from our law. So while there are principles that are the same, there are fundamental differences. So I think it's good to use them, but I'd caution against using them directly because it's not the same Act. Our Act is considered to be the most advanced in terms of supporting autonomy in Europe. So like other jurisdictions are much more restrictive. Ours isn't yet. So in terms of that, it's not here yet. But so I'd kind of caution against. It's not directly comparable, I think, is the issue.
And I think possibly some of the education and training that we will develop before year end on consent will embed some of the principles of the Act and will set a good grounding for the Act going forward.
Great, that's great. And moving on now to address the question. So Travis Ryan has asked about the possibility of a masterclass in supporting people with profound intellectual disabilities in residential services.
Yeah, we'll make a note of that. And actually, we were at there was a session in Cork in UCC yesterday in the School of Nursing on communicating with people who have severe to profound intellectual disabilities. So if you want to make contact with us directly, Travis, we can give you their details as well, because I think that would be very helpful. There's some very interesting work that they did that would be useful for you to know about as well.
You have Quiva's email address there, Travis, if you wanted to contact Quiva there. So from Lucy, she's very interested in the development of a separate do not resuscitate CPR policy. Will this policy be rolled out across the HSE?
Yes, it will, but we actually have it developed, and I suppose in the interim, what a good policy is that, or part of it as per the National Consent Policy, there's also a really good policy developed by the UK, the Resuscitation Council, which we hope to kind of use as a basis for our policy going forward. But the principles, as outlined in the National Consent Policy, as it currently stands, apply, and it's good you can implement those in practice. The problem is that they don't always be implemented as per the policy.
Yeah, I suppose the logic and part of our focus on consent and DNA CPR this year is, in the absence of full commencement of the Act, there are things that we need to be doing right now to support decision making, and we know that many people don't know about the National Consent Policy, that don't follow the National Consent Policy in terms of informed consent. So we decided that our focus for this year was to really support staff in how do you get informed consent, particularly with people whose capacity is in question or maybe shortly in question, and to do some really good pieces of work this year so that we're ready for full commencement. So we're not saying there isn't a consent policy, there isn't DNA CPR now, but it's just not followed. So we want to try and, what are the enablers to get people to engage with that more effectively, and that's what our plan is for this year.
Lots of questions. Thanks a million. So thank God we've some time here to deal with them. So just actually from Ciara, there seems to be a common thread here about just advice, practical advice with dealing with kind of, frontline issues with patients and their next of kin, etc. So advice for dealing with parents of people with disabilities who have up until now been asked for their permission or consent regarding access to money, activities, etc.
Jacqueline?
This is a very common question because, as we know, it happens in services all over the place. It's a hurdle that's going to have to be crossed. In terms of kind of really practical advice, I think there's a bigger issue around kind of informing and supporting families to be aware of the Act and the fact that the Act is coming. And I think that's kind of a first step around the whole part of you need to be able to support people to make decisions and to make decisions for themselves, whether it is that activities or whether they're wanting to go to the cinema as opposed to going to a day service. And I think that there's a number of people who've never been supported to make those decisions. So for some people, you're going to be starting from the very basics of what colour do you want to wear? Do you want to wear the red top or the green top before you can even get to the stage of what activity do you want to do or how do you want to spend your money? But yeah, it's a big thing that does need to be kind of worked on and supported, and I think it's something we need to work with families on.
Okay. So just to say to you, we've just come from a meeting this morning with the Decision Support Service, and one thing that we're planning for later on this year is a workshop with families. Those that are, because there are some families that are really unhappy about the Act and some families that are nervous about the Act, and then others that you could see in the video that are really supportive of it. But to have a discussion, like a workshop discussion about what is it that you need to know about it and what supports do you need as a parent to be able to engage with the principles of the Act. So we're going to do that later on. So I suppose just to answer your question as well, that there aren't any easy answers, and I think this is not just in disability, this is in every service where we've always relied on family, sisters, parents, mothers, fathers, etc. to make decisions, and now we're saying, well, actually you don't have the right to make that decision. So I think we need to manage it in a way that's sensitive, that's respectful to the person but also to their family. But I think that there will be very difficult decisions to be made, but I suppose what we're trying to do is figure out a way of how to support staff to be able to do that without much conflict, but we completely appreciate that is going to be a conflict area as well.
Just to say, if there are any questions that we don't get to address, you have the email addresses here, that you can contact any of the team afterwards, but we'll try and get through all of them that we have here. So there's one from Nicholas Codd around how much does it cost to set up ADM, please? So Siobhan in Beaumont, don't know what that's.
Okay, I'm assuming how much does it cost to put to have a supporter in place. So at the moment, the only supporter that you can get is an enduring power of attorney, and that varies the price of that. So you make your enduring power of attorney when you've got capacity, then you register it when you lack capacity. The making of it, depending on what solicitor you go to, can be anything from €500 to 1,000, depending on what part of the country you're in. To register it, it depends on what kind of assets you have. So it could be 1,000, could be 1,500, it depends. Like, so obviously if you've got a large estate and you've got lots of properties and there have to be searches and stuff, that's how things add up. But you're talking about €1,000 in total, really, for an enduring power of attorney. Okay. In terms of the other arrangements under the Act, there won't be a cost for the first two. There will be a cost for the third one because that's court appointed. And again, it'll depend on, the cost will depend on how often you have to go to court, who you involve with, and again, some of that kind of minutiae of detail has been worked out by the Decision Support Service. Obviously, cost is something they have to address because many people that are affected by this will not have assets, will not have property, won't have any means, or very little means. So, yeah, so that's been worked out at the moment.
There is a provision for legal aid in the Act to support people to go to court to get those appointments. But again, as Caoimhe said, that still needs to all be kind of ironed out and sorted and things. So.
Okay, so just moving on to the other questions here. Are there timeframes to engage the court and the High Court?
I'm assuming that's coming from those that are involved in wardship applications where you're talking between a 3 to 1 year wait. The cases for, and again, it's the main one that will go to court is the decision-making representative, and that'll be through the circuit court. There'll be a number of circuit court appointed judges. We've flagged that it must be a fast-tracked system, that people are not, because obviously there'll be situations, but we don't have, because we don't work with the court directly, we don't have an actual time frame as yet. But again, all of those issues have been flagged that it must be an expedient system.
Just flying through the questions here to try and get through the end. Yeah. So Kelly McGuire has asked a nice one here around admission services and how they still ask for the details of next of kin. Any comments on that? Okay.
So one of the things that we plan to do is a campaign around next of kin, but part of our difficulty is that if we get rid of the name next of kin, and we know this particularly in hospitals, we must replace it with something that works for the patient information system. And there's kind of different theories on this, that do you have emergency contact, but that's not just what the current next of kin does. Do you have a nominated person, or do you have a person with legal authority? So we're going to kind of road test it with a number of sites to see what will work before we change it fully, because people have said, let's test it out. So we'll be approaching a number of hospital sites and community services in particular to see what's going to work. And then we'll get back to you in terms of this is what needs to be changed. It'll be a single message, no more than GDPR, that it'll be one system that we try.
Great. Judy, thanks for your comment there about functional assessment and who does it. So that was answered earlier. We have another one here from, when working with acute drug users, how may services best support decisions, and could those decisions be considered to be not functional due to impairment?
Marie, do you want to take that one?
Again, it goes back to presuming the person has capacity, and that's your starting point. And then moving on to, if they don't have capacity, what supports and how do you support them in their decision making? And again, it's looking at, does the decision need to be made now? Can it wait? Can you wait until the person is more lucid? And the other point is that, does the drug impair them so much that they can't make the decision? Is that a normal functioning for them? And are they making everyday decisions with that impairment? So really it's gone back to presume the person has capacity, supporting them whenever, and ensuring that you take the least interventionist approach when you do have to make an intervention.
Yeah. But there might be situations where they lack capacity based on the functional approach, having presumed and supported. So you presume, you support, but there may come a point where they just can't make that decision, and somebody else is going to have to make the decision on their behalf, or support them to make that decision.
Just one or two more before we wrap up. So from Florence Hogan, she's asked about the current status for deprivation of liberty. There's no statutory provision in the DOL safeguards. The ASV's CUH case has caused concern.
Okay, so that's the AAC case, which was in the High Court last week. And At the moment, we do not have a law on deprivation of liberty, and we don't have deprivation of liberty safeguards in our current jurisdiction. There was a case in the High Court last week. The judgment hasn't been issued from that case yet. The Department of Health are working on heads of bill. There was a draft heads of bill out last year. They intend to continue working on that this year. Once I suppose there's quite a bit of work to be done to get heads of bill that will work for services. That'll happen later on this year, but until that time we can't comment any further because we're awaiting the Department of Health, because it's the Department of Health that are leading on that. So it is a major gap in terms of practice at the moment.
Does that address this question then? So are we being advised to act in the spirit of assisted decision making currently? Where is protection in the event of unwise decisions, e.g. alcohol intake causing harm?
That's a different question. Yeah, that'll be.
Yeah.
So,
Sorry.
okay, so just to say it again, are we being advised to act in the spirit of ADMA currently? Where is protection in the event of unwise decision? Alcohol intake causing harm. So it's
going back to the point
yeah.
of the person having capacity and making an unwise decision, and it's looking at what mechanisms you have put in place to protect that person, as you do on a daily basis, in relation to all of the people that we deal with when they come into our services.
Yeah.
There's nothing really different about it. If you know somebody has a certain difficulties, what mechanisms have you actually put in place to deal with that risk?
And I suppose what the State Claims Agency have said is you just need to document really clearly that, so if the person, you've outlined the risks, you've highlighted the risk, you've walked through it with them, you've explained it in every possible way, the person still has capacity but will continue to make an unwise decision, that's their right. So you can't, so you're kind of stepping into assault or kind of other areas of other deprivations then if you try and intervene, I suppose. And it is an area that people are very worried about in terms of what happens when something happens, as it is right now. But I guess a person who has capacity and continues to make unwise decisions has that right, as all of us do. We can all make...
That links into the next question from Eugene very nicely around a case that I think he's put in the link there from the High Courts about... I think it's
Cork University.
with the elderly woman.
Yeah, so that's the same matter that we just spoke about.
Yeah.
That is being addressed by the Department of Health, but it's also we're awaiting the judgment from the Supreme Court as well. But I suppose just to reiterate, the Department of Health are working on this at the moment as well. So
yeah, great. We have one from the National Ambulance Service, and where does that fit in with the Act? Is it just that it's
I wonder, is that the National Ambulance Service or is that the National Advocacy Service?
Oh, possibly.
So,
Brenda, if you'd like to clarify there.
Yeah. If it is the National Advocacy Service, well, then it directly fits in. Yeah. So it's so the Act supports advocacy. The Act is directly that it supports a person to have an advocate, and they may have an advocate as well as a decision maker. So it's that it actually reinforces the role of the National Advocacy Service.
Great, and we've one final clarification there. Nicholas was asking about the cost of assisted decision making setup.
So we addressed some of that earlier on. It depends on which decision maker. So the court appointed one, there will be a cost, and some of that is. It depends on what legal team you have. It depends on whether you are entitled to legal aid. It depends on how complex the decisions are. It depends on, how often you have to go to court. So there's a number of, and any of you that have been involved in court will know it's expensive. It won't be, and it comes out of the person's estate.
And we have a lovely comment there from Joanne to finish off with, I think. So having statutory right to home care options to support will and preference would be a game changer for all of our patients, and a great thought-provoking presentation. So I think that's a nice comment to end on. And I suppose from my perspective and from our QI Talk Timers, just to thank Caoimhe, Jacqueline and Marie for giving their time up today for such an excellent webinar. Just to say it's something obviously very dear to us all. We all know somebody that this is going to affect, and it is really important that us as healthcare providers, we know the implications it has for us. So stay tuned, because there's a lot more to come. And I suppose we will plan a further Talk Time webinar possibly later on in the year to follow up on this. So just thanks again for an excellent webinar.
Thank you, everyone.
And just to say, there is another webinar coming up. We have a few more left before the summer break, so we have 3 more webinars left, and we have our next webinar on Tuesday the 28th of May, and it's actually coming from the NRH, from Valerie Toomey and a few of the team there, really around a more organised approach to quality improvement. So if you work in an organisation and you'd like to try and link in around tools and how to go about it to support quality improvement in your organisation, listen in and you'll hear about how the NRH went about that in partnership with the National Quality Improvement Team. So that's 2 weeks on Tuesday. Also, just to say, this has been recorded. It will be up on the QITalktime webpage, so if you just Google QITalktime, it'll come up as the first hit, and go in there, and the slides and the recording will be available to listen back. So thanks again for everyone for joining. We hope that you can join on the next one, and hope you get to enjoy some of the sunshine today. Thank you.
Thank you.